and it wouldn't be a great light, right?
Yeah. And so I'm justified in worrying about jurors who have been exposed to media. Should I be worried about you?
No, I really haven't. I have not been exposed to that. I do not like social media. I've never liked it. I find it, I think it's destructive to people, so it's not. Yeah. So I haven't done that whole thing at all.
And I tried to help you out to go on your trip, and you turned me down.
We'll still go. We'll go whenever.
Okay. All right. So you don't really want to be on this case, do you?
I don't know that anyone in their right mind would really want to be on this case. No, I really don't think so. But you don't know me, and you don't know that I have a real sense of right and wrong and real sense of duty. Let's put it that way, duty. And if this is my duty, that's what I do. You know, it's not about me.
That's right. No, so thank you for that. And so we appreciate jurors who come here and take time out of their lives to help us settle a case, because we obviously haven't been able to settle it yet. So, with your state of mind, do you have any concern about your ability, with the news that you've been exposed to? Are you concerned about your ability at all to presume my client innocent?
No.
Okay. All right. Thank you.
All right. Thank you, Mr. Archibald. Then the court hearing no challenge for cause on this juror. Ma'am, we'll have you return back to the jury room while we talk to the other jurors, and then we'll let you know for further instructions. We'll have juror 776 come in next. All right, welcome back, juror 776. We're conducting some individual questioning for jurors, and there are several that have some prior information or knowledge about this case, so we can talk about that openly here without others hearing what you may or may not know about the case. The court has reviewed your questionnaire, and it does indicate some detail of knowledge here. Let me first ask a question. In terms of what this defendant's been charged with in this case or anywhere else, before I advised you of the charges in this case when you came in to get your questionnaire last week, had you heard what she was charged with at all?
I don't feel that I had heard exactly what they were, but I knew that there was charges brought against, but I don't recall knowing the details of what they were.
Okay, and did you know where charges may have been filed, including Idaho or anywhere else?
No.
Okay. I did not. Have you watched any of the Beyond Local News documentaries or specials or movies or anything about this case?
No.
Okay. That would conclude the court's questioning as it relates to the media issue in this case. The state can inquire if you want to question this juror relating to either the social or any of the media exposure, as well as any other issues you think were more appropriate outside the presence of other jurors.
Your Honor, may we approach briefly the court and with defense counsel?
Yeah.
that like white noise.
All right, the court had a sidebar there with counsel off the record, and at this point we'll suspend further questioning for juror 776, and if we have additional questioning we'll let you know, but you can go ahead and return back to the jury room with the other jurors, and we'll have you come back in for further instructions here shortly. So let's next bring in juror number 876. Counsel, while they're coming in also, I'll just briefly indicate that the juror who wouldn't sign the affidavit because they said they didn't follow the instructions was juror 781. They were dismissed on a hardship question, so that is the issue that came up on that, and I won't address it any further unless counsel wishes to, but that was juror 781. All right, welcome back, Juror 876. We had some additional questions as relating to responses in your questionnaire about some exposure to this case through media. The first question I'll have is, before coming in to get your questionnaire and then again today, were you aware specifically of what the defendant was charged with either here or anywhere else?
I was aware that it was a murder trial. That's basically it.
Okay, no further detail beyond that in terms of what you already knew?
That is correct.
Okay. All right, if the state would like to conduct any additional voir dire with this jury, you may do so at this time.
Your Honor, the state doesn't have any questions for this juror.
All right. For juror 876, does the defense have some questions, Mr. Archibald?
Juror 876, do you recall filling out your questionnaire last week?
I do.
And you made a comment in there that it's suspect where her kids were found. Do you recall writing that?
I do.
And where would you get that information?
I became known of the trial from the beginning where the children have gone missing, and then up to the point. I think I've only read about 2 articles, up to the point where the kids were eventually found. I don't particularly remember where they were found. I just know that they were found.
Okay. And so the media that you were exposed to was what?
It was a news article.
Did you watch the Dateline special?
I did not.
The Netflix?
I did not.
The 2020?
No.
The 48 hours?
No.
So the media that you've been exposed to was just, was it in the newspaper or read it on your phone?
It was on my phone. I was scrolling through Facebook, and I follow KTVB Channel 7.
Okay. And so based upon that, that's where you gained information about this case.
That is correct.
And did it paint my client in a good light or a bad light?
I can't say either way.
Okay. So you don't have any bias against her now?
I do not.
Based upon this one article, you haven't presumed that she's guilty rather than presuming she's innocent?
That's correct.
Okay. All right. Thank you, sir.
Thank you.
All right, that will conclude the individual voir dire of Juror 876 then. Thank you for coming back in. I'll have you escorted back to the jury room, and we'll give you more instructions here shortly. We'll next move to Juror 894. All right, welcome back, Juror 894. At this stage of the proceedings, we'll just have some individual questions for you because you indicated some knowledge of this case from the news or other media. Not much is indicated in your questionnaire. Looking back over what you put in the questionnaire, do you think those are still accurate answers about the level of knowledge you would have about the case?
Yeah, I know hardly anything, but I remember seeing like little snippets on Facebook, but I didn't live here at the time that the crime was committed, or I had just moved here, so I didn't even really know what it was about. So I didn't pay very much attention to what was happening at the time, honestly. I had too much going on moving here.
Okay. Before I stated what the charges in the case are, both last week when you got your questionnaire and this week, before that time, were you aware at all of what the defendant had been charged with here or anywhere else?
I knew that it was a murder case, but I didn't know the details of who was killed or the relationship between them, except for in like a super vague kind of, I don't really know how to explain it. Like I kind of knew in the background, but I didn't even recognize her name when you said it.
Okay, I appreciate your responses there. Those are the court's questions. Does the state have questions for Juror 894?
Juror 894, I think you put in the questionnaire and then you've expressed again today that you know very little about this case.
Yeah, that's correct.
From what you have seen or heard before coming in last week for jury duty, does anything about that information cause you concern with your ability to be able to set that aside and only consider the evidence presented in a trial in this matter?
No, I think I can do that.
Does anything about what you've been exposed to or heard or read cause you concerns that you could not be fair and impartial in a trial in this matter?
No.
I have no further questions.
All right, thank you, Ms. Blake. I'll ask the defense now if they have any voir dire questioning for this juror individually. Okay, thank you for coming back in then. We'll have you brought back in here in a moment when we finish the last ones and give you further instructions. And the court will indicate on the record there was no challenge presented by either side. Let's next go to Juror 929. right, welcome back, juror number 929. We've brought you in for some individual voir dire questioning, either as it relates to potential media exposure in the case or other topics that the parties would wish to bring up outside the presence of the other jurors. The questionnaire you've filled out, and we appreciate you putting your responses in there, indicates you do have some knowledge of the case. Let me start off by asking you, since you've had time to think about it, since answering your questionnaire, is there anything else you think you should supplement on that or change based on what you know about this case?
No.
Okay. Before I read the charges last week during the part where we handed out the questionnaires and again today, were you aware of what the defendant had been charged with here or in any other place?
Very little, not completely.
Okay. What is it that you had heard about what the charges were?
I did hear that that the defendant was charged with the murder of the two children, and that was about it.
Okay. At this time, I'll pass for voir dire questioning to the state. Any questions you have, that concludes the court's questions.
Juror 929, I think, again, on the questionnaire and then today, again, you've indicated that you've had very limited exposure, heard very little about this case. Is that correct?
That's correct.
I think on the questionnaire you had indicated you heard about the case initially, but you don't watch the news.
Right.
And also the things you knew about Miss Vallow Daybell was that she was married to Chad, LDS, and accused of murder.
That's correct.
And you also indicated the first time you heard the victims' names were of the reading of the indictment by the judge.
That's right.
Is that all correct?
That's correct.
So with hearing about the case initially and then the part about what you knew about the defendant, does anything about that, knowing that information, cause you concern about your ability to sit and listen to the evidence and only consider the evidence presented at a trial in this matter?
No.
Does anything about that information or what you've seen or heard cause you concerns about your ability to be a fair and impartial juror in a trial of this matter?
No.
I have no further questions.
Okay. Thank you, Ms. Blake. Mr. Archibald, any questions from the defense on this juror individually?
Juror 929, there's been a lot of media exposure about this case. Where do you get your news information?
I mostly subscribe to financial and sports, and sometimes some food websites, and that's about it. Okay. We don't have TV in our house. We stream, and I've kind of cut down what I see because I don't have time to read everything. So,
okay,
yeah.
For the streaming news about this case, there's been Netflix. Did you see the Netflix?
We don't have Netflix.
How about Dateline or 2020?
Don't watch those shows.
And so there's been books and movies about this case.
None of that.
Okay. And so what you've heard has just come up on your social media like a Facebook?
I don't even have social media. That's how backwards I am. Don't have time.
And you're a financial planner.
I am.
And so the information that you would have learned about this case would have come from where?
Well, probably from an Apple news feed or something of that nature. I think I initially saw there were missing children, and that's probably first couple articles I think were about that. And then I stopped following.
Okay.
So.
And are you comfortable in your state of mind sitting as a juror on this case?
I am.
You've sat on two other juries, and in that experience, the defendant has to start out with a clean slate. Based upon what you know already from news media, are you comfortable that you can start out with Lori Vallow Daybell with a clean slate?
Yes.
Okay. So if you were asked to judge her, what you've learned previously won't play into that.
No.
All right. Thank you, sir.
Thanks.
All right, thank you, Mr. Archibald. At this point, then, that'll conclude the individual voir dire of Juror 929, and the court's heard no motion or challenge on the record as it relates to this juror. So we'll bring you back in here just pretty quickly once we finish the last two and give you further instructions. Juror 1039. All right, Juror 1039, thank you for returning. This is the time we're going to discuss individually with you any information you may have about previous knowledge of this case from media sources. You've identified those in your questionnaire, so we want to talk to you about those outside the presence of other jurors.
Okay.
Let me first ask you, before I read the charges filed in this case both last week and today, did you know what the defendant had been charged with here or anywhere else?
Not specific charges. I think I had a general idea.
Okay. And in looking at, you talked about other news sources. Beyond the news, did you watch any kind of specials, documentaries, programs, movies, or anything that focused on this case before you came here?
No, not any documentaries.
All right. The court will pass at this time its individual voir dire to the state and see if the state has any inquiry.
Hi. So on your questionnaire, just looking at that, I just want to go over a few things. It looks like you indicated that you have maybe seen some news programs on KTVB or other Idaho news sources.
That's correct.
Is that still correct? Have you watched anything else?
I have not.
It also looks like you indicate you don't know who Tammy is.
I didn't recognize that name.
And that Tylee and JJ were missing kids of Lori Vallow and or Chad Daybell.
That's what I understood.
And that they went missing in 2020 and they were found in southern Idaho.
That's what I remember. It may not be correct.
Do you recall and whether it's correct or not, do you recall anything else that you've heard or learned of this case?
I think I remember that Lori and Chad were, when they were arrested, they were found out of state. I thought in Hawaii, but not in Idaho.
And with that, with the information that you may have heard or you think might be accurate, is there anything about that causes you concern that you would be unable to sit through a trial and only listen to and weigh the evidence presented during that trial?
No, I realize that I only have a small subset of the details and would like to hear more of it.
And anything about the details that you do have or that you think you have that would cause you concern that you wouldn't be able to set those aside if that's not what was presented as part of the evidence?
No, I'm open-minded.
I think you'd also indicated that the action seemed a little odd for a parent of missing children, but you hadn't formed a firm opinion. Is that still the case today?
From what I think I know or read, it did seem odd to me, especially being a mother, that the parents of missing children were out of state when their children were missing.
Is there anything about thinking that or having those thoughts that would cause you concern that you could not sit and hear the evidence and set those thoughts aside and fairly weigh the evidence presented?
No, I could just set that aside and hear full evidence.
Anything about your previous exposure to this case that would cause you concern about your ability to sit as a juror in this matter and render a fair and impartial verdict?
Nothing I can think of.
I have nothing further.
All right, thank you, Ms. Blake. Mr. Archibald, if you'd like to conduct individual voir dire, you may.
So the comment in your jury questionnaire, her actions were odd for a parent of missing kids. But what media were you relying on for that?
Probably a news article online.
Okay. Is that where you get your news?
Usually, yes.
All right. Did you watch any of the specials about this case?
No, I did not.
Did you watch Netflix or Dateline?
No. I didn't know that there were specials about them.
Okay, 48 Hours or 2020?
No.
And the news that comes to you, is it on your phone or on your TV?
Usually through my phone or a laptop.
And the laptop, so that's the internet news, or?
Correct.
Like from Google or Yahoo, or?
Yeah, correct.
And so at some time you formed an opinion that she's not acting like a mother should act.
From the limited knowledge that I had, it seemed odd. But.
Yeah. And so is my client going to have to prove her innocence to you?
No. I realized that I didn't have all of the details, so
yeah.
I know that there are large pieces missing.
And it's okay to be honest about your feelings. You filled out the questionnaire last week. That's all we're asking of you, is to be honest about that.
Okay.
And so my concern as her lawyer is having people on the jury that have already judged her. Like, hey, Mom, your kids are missing. Why aren't you doing this? Why are you doing that? Is that something that was going on in your mind?
Possibly.
Yeah. And so, and you're the one who knows what your state of mind is. So are you comfortable being a juror on this case with how you felt about this case?
Yeah, possibly. Yes, I am comfortable. And quite some time has passed. I haven't followed the case closely recently.
Yeah. Well, will my client have to prove her actions to you about when her kids were missing?
No, that is not her responsibility.
Okay. So you acknowledge that my client doesn't have to prove anything during this trial.
Correct.
And so again, this is a tough question because you're the only one who knows right now. But are you able to presume my client innocent?
Yes.
Okay. All right. Thank you.
All right, thank you. That'll conclude then the individual voir dire for juror 1039, and we will get back to you here just quickly. We've got one more person to talk to. The court finding no challenge made on the record to this juror. Juror 1051. All right, Juror 1051, welcome back. We've been conducting some individual questioning for those that have had any prior knowledge or exposure of this case. You did make a reference to that in your questionnaire. You didn't have a lot to say about it, a little bit, enough for us to ask you an individual question here. Before I let the attorneys ask you questions, I'll just ask, prior to coming in and having me advise you of what the charges are in this case, both last week and today, did you know anything about what the defendant had been charged with, either here or in any other place?
In my answer, I was just trying to be as truthful as possible. I don't really know what I don't and do know. I've obviously heard the name, I've heard about it, but I hadn't really followed the case or anything like that. I know my wife was listening to a Dr. Phil podcast or something like that. I was off building the kids' play set, so I really wasn't paying any attention to it. So I don't really know that much about it, but I can't say I didn't know anything about it either.
Okay, well, I appreciate that information. That's helpful. You stated you heard things from TV. Have you watched any kind of documentaries, special programs, movies, dramatizations about the case, anything like that?
No, I don't really follow the news or anything like that.
Okay, that concludes the court's questioning for the juror. Does the state have any questions for juror 1051?
Juror 1051, I think you just indicated on your questionnaire, you'd indicated limited knowledge and that what knowledge you had would have come from the TV. Would that still be accurate?
Just over here in the background, yeah.
And so when you're talking about overhearing in the background, to the best of your recollection, was that the Dr. Phil that you referenced that your wife may have been listening to?
I think she was listening to that, yeah.
Some
Off building a construction project, so I really wasn't paying much attention to it.
So you haven't yourself sat down and watched any news programs, sat down and read any news articles? Based on the limited knowledge you have or what you may have overheard, is there anything about that that causes you concern about your ability to sit as a juror in this case and only consider the evidence presented and give it the weight you feel it's due?
I don't believe so. I think the only thing is I heard the name. That's about my extent of my knowledge.
And anything about that that causes you any concern with your ability to sit as a juror and render a fair and impartial verdict in a trial in this matter?
No.
I have nothing further.
Okay, thank you, Ms. Blake. Mr. Archibald from the defense, any individual voir dire for this juror?
I don't have any questions.
Okay, thank you, Juror 1051. That concludes your individual voir dire. We'll have you return to the jury room, and before the rest of the jurors are brought back in, I'm going to have a brief just discussion with counsel here about our schedule. We're behind, obviously. I think it was a little overly ambitious for me to think we could go through 4 of these groups today. By my count, I think we've done 2. Is that right? So we've got jurors that were scheduled to come in 2 this afternoon. I do think we need to get through one of those 2 remaining groups, and we need to make some adjustments to the schedule here. So I believe the presumption would be we'll move on to the 3rd group next and potentially allow that 4th group to be excused. Otherwise, we're going to go really late, and I don't think that's what we want to do. Let's do this. We'll bring these jurors in, complete this group. I'll briefly meet with administration and kind of see where we are, and then I'll come back on the record and talk to counsel about scheduling where we are with our next group coming up. So at this time, if we'll just have the rest of the jurors brought in, we'll get this group completed, and then we'll take things up from there.
Your Honor, may we start the simulcast back?
Okay, yes, thank you. So of that group, I think it's just 776 that was going to be dismissed. Let me just consult with my staff attorney briefly. So we need to get to the number. Thank you. Please be seated. All right, at this time, the court has completed the individual voir dire. If you'll give me just a moment, I'll confirm that we've got the simulcast back up and running.
Yes, Judge, it's up.
Okay, thank you. All right, counsel, the court understands that after concluding individual voir dire, let's see, juror 1013, we did not conduct individual voir dire, and then based on a challenge that was raised for cause, the court concluded that juror 776 would be excused, finding for cause based on individual voir dire in the questionnaire. So, as my records would indicate then, the jurors that would be remaining to be passed for cause at this time, I'll go through a list and confirm with the state and the defense, are jurors numbers 745, 755, 756, 776, 876, 894, 929, 1013, 1039, and 1051. Does that seem right with the state?
Your Honor, I think you included juror 776 and had previously indicated that juror would be dismissed for cause. Other than that, the state agrees.
All right, thanks for the correction, and I agree with that as to 776 based on that ruling I made when we started. With the exception of that correction, then, does the defense agree those are the remaining jurors at this point?
Yes, Your Honor.
Okay. With that clarified, then, I'll ask formally then, noting we're back on the record on the case, with that remaining group I just indicated, does the state pass that group for cause?
Yes, Your Honor.
All right, and does the defense pass that group for cause as well?
Your Honor, I think just for the record, since there were challenges made throughout the week, that those challenges are still of the record. So I acknowledge that this is the group that we have today.
Okay. I think that's a fair point, Mr. Archibald, that there have been objections or challenges on certain jurors that have been overruled by the court. All of those are still preserved, and so perhaps that question ought to be modified as I ask it, but I do note that you have preserved challenges for certain jurors that were ruled by the judge to still be able to return for purposes of the peremptory challenges. So I'll note that on the record. All right. So with this remaining group then, juror 776, you'll be excused. And as I mentioned with the prior jurors, that any attempts to contact you that are unwanted by you, you can report those to the court, and please respect the fellow jurors in this process if you do choose to discuss your experience with anyone. For the remaining jurors here, you have been passed at this time for cause, or any objections were overruled by the court, so you will be returning. We'll continue to question additional groups such as yours until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You're going to be instructed to contact the jury commissioner. We'll give you a card with his contact information. He'll be providing you additional instruction regarding when you will again be required to return, when we'll assemble the final group of jurors for peremptory challenges. While you are waiting for that, again, please bear in mind the court's admonishment to not discuss the case or investigate the case during this critical time frame, so that you can remain impartial in the case as we've previously determined. And if anybody is trying to contact you or for any improper communications, please note that and report that to the court. And I'll also have you complete that admonishment indicating that you have not researched or looked into the case since we last met, whenever that is, that you are instructed to return again. So that will conclude the voir dire for this particular group of jurors. before they're dismissed with instructions to return. Anything further from the state?
Nothing further, Your Honor.
Okay, from the defense?
No, Your Honor.
Okay. That will conclude this panel, and we'll take a recess here, and then we'll discuss our scheduling and where we stand for the day. I'll meet briefly with the trial court administration also on that issue, and we'll come back on the record here in about 15 minutes. Take a break.
All right, please.
All right, thank you. Please be seated. And before, again, we bring the next group in, we'll make sure to discuss with counsel scheduling and where things stand, and then we'll get this third group going as soon as we can. All right, thank you. We'll go back on the record now on case CR 22-21-1624, State versus Lori Vallow. This is the time we have set aside for juror for Dyer. We are about to commence with our third group of proposed jurors in this matter. Given the scheduling of where we are, we've made some adjustments to the schedule. I'd like to start there, and I'll indicate that I held a sidebar with counsel off the record to discuss the scheduling of these remaining jurors for today. Counsel, you've been given a chart which would indicate our group 3. We had intended to try to get to a fourth group today, but we're not going to have time to do that, clearly. We have groups lined up for tomorrow. So the group 4 jurors for this afternoon on my list started with a number 1782, and then the number restarted again, but ending with a juror number 389. Hopefully we're all looking at the same group for organizational purposes, but my understanding is the parties agree that we can allow those jurors to be put on a standby status and released for the day. We'll finish up with Group 3 today, and then if we need to, we can recall Group 4 at a later date. Does the state agree and stipulate we can do that at this time?
Yes.
All right. Does the defense agree as well?
Yes, Your Honor.
Okay, counsel, and I'll also just indicate on the record, given the random nature of how their juror numbers were assigned, does the state raise any objection to the manner in which we're seating or calling the jurors, given that we're going to change that schedule?
No.
Does the defense raise any objection to the manner or method in which we're impaneling or seating those jurors on that list?
No, Your Honor.
Okay, thank you for your cooperation on that, counsel. As I mentioned, then tomorrow we'll plan on doing 3 groups like we did today instead of 4 to allow adequate time for your voir dire. We'll have groups tomorrow tentatively scheduled for 9 o'clock, 11, and 2 o'clock, and we can discuss that more on the record tomorrow. With that in mind, then, we'll bring up our final group of jurors, Group 3, and have those jurors brought in at this time for voir dire. We are back on the record on case CR 22-21-1624, State versus Lori Vallow. The attorneys for the state are here present, and the defense as well, along with the defendant. We're continuing voir dire examination of groups of jurors. The court at this time will conduct and allow parties to conduct voir dire examination of one more group this afternoon. Counsel, I've been handed the seating chart for this group, and to make sure everyone's on the same page, we should have jurors with numbers from 1106 to 1758. Does that comport with what the state's got?
Yes, Your Honor. It does appear maybe one juror is missing.
Okay. Do we have, we'll go ahead and take a roll call at this time then. Let me just cover a couple other preliminary matters. There is a courtroom conduct order in effect. These proceedings are being simulcast to two separate viewing locations, one in Ada, one in Madison County. The use of electronic devices to record or photograph or transmit any sounds or images from those viewing areas is prohibited by that order, and the bailiffs are authorized to confiscate any devices used to do so. I'll also note that the court received the juror affirmations from each of the jurors in this group, indicating that they've complied with the previous order once they were released after they completed their questionnaires. So we appreciate you following those orders and completing those affirmations. At this time then, I'll finally advise counsel again, remind you to only refer to jurors by their number, what we call the red card number, because that's the number on the red card that you have. And we'll take a roll call at this time to ensure who's here and determine who's not. So, Madam Clerk, if you would start with the roll call, starting on the front bottom row, lowest number, we'll go in ascending order to the second row.
When I call your juror number, if you could please answer off for the record. Juror 1106. Here. Juror 1133. Here. Juror 1210. Here. Juror 1238. Here. Juror 1266. Juror 1273. Juror 1276. Here. Juror 1323. Juror 1370. Here. Juror 1527. Here's the FTA. Juror 1569. Juror 1571. Juror 1589. Juror 1658. And Juror 1758.
Okay, thank you all. If anyone is contacted or hears anything from Juror 1527, please advise the court. I will admonish that for their non-appearance, they could be subjected to contempt under Idaho statutes 7610 or 22085. We'll take that issue up at a later time with that juror who has failed to appear. Ladies and gentlemen, thank you for returning back this afternoon. We appreciate your patience. I know you've been here for some time. You've been recalled in this case as prospective jurors now before us. I'll reintroduce you quickly to the staff that's assisting today. I'm Judge Stephen Boyce from Fremont County, and I'm in charge of the courtroom in this trial. The court clerk seated to my right is Shannon Holstein, who keeps minutes of the trial proceedings and marks trial exhibits and administers oaths. There are bailiffs here assisting us, Deputies Ravello, Holmes, and Beish. They'll help with the courtroom order and assisting in moving the jury around. The court reporter, Patty Bath, takes a stenographic record of everything said in the proceedings, and then my staff attorney is Courtney Stallings, who's seated at the table over by the window, and she will assist me as needed with legal issues that may arise during the case. Each of you is qualified to serve as a juror of this court, and you've filled out a questionnaire that's now been reviewed by the court and the attorneys. This is the process of selecting 18 jurors altogether, which is 12 jurors and 6 alternates from among the group. At this time, we've already gone through the roll call and indicated we had one juror fail to appear. I'll again advise you of the jury selection process. and reintroduce you to the parties and their lawyers and summarize briefly what the case is about. When I introduce an individual, please stand and then face the jury panel, then you can retake your seat. This case has been brought by the state of Idaho. I'll sometimes refer to them as the prosecution. The state's represented at this trial by Lindsay Blake, the prosecuting attorney for Fremont County, and by Rob Wood, the prosecuting attorney for Madison County, as well as Rachel Smith, special prosecutor appointed in this case. The defendant in this case is Lori Vallow Daybell, who's represented by her attorneys Jim Archibald and John Thomas. Thank you, counsel. This case is a criminal matter, which means that the defendant has been charged by the state of Idaho with a violation of the law. When you were last here to receive your questionnaires last week, I read in detail from the indictment the charges that have been filed in this case. I'll again reiterate a brief summary of what's been filed in the indictment in this case. With regard to the defendant, the state of Idaho has alleged that the defendant, Lori Vallow Daybell, committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, and count 7, grand theft. The defendant has pled not guilty to all of the charges. And please remember, this is simply a description of the charge. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next address the juror's duty in this case. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I'll later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of the trial, including the jury selection process, you're instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I'll ask that the court clerk swear the entire jury panel for this voir dire examination. Ladies and gentlemen of the jury, if you would please stand and raise your right hand, I'll have you placed under oath.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as trial juror in the cause now on trial? So help you God.
Thank you. You can be seated. Will the state stipulate that the jurors are now properly called, impaneled, and seated?
Yes.
Will the defense also stipulate that these jurors are properly called, impaneled, and seated?
Yes, Your Honor.
All right. Thank you, counsel, for that. I'll next discuss the nature and purpose of voir dire. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand that this questioning is not for the purpose of prying into your affairs for personal reasons, but is only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand. And at this stage also, I'd say raise that red card, which helps us identify who you are. And when you're called upon to speak also, you can just identify yourself by raising that card, please. These proceedings are being recorded stenographically, so when asked a question, please make a verbal response such as yes or no. Try to avoid saying or nodding or shaking your head, because then the record doesn't come out clear about what your answer may have been. In addition, please wait for anyone questioning you to complete their question before you speak, so two people aren't talking at the same time, which is difficult for the court reporter. Importantly here, if any answer to any question that's raised would be embarrassing for you to answer publicly, let us know, and we will have an opportunity to discuss those matters with you individually in a more private setting outside the presence of your fellow jurors. Also, in this case, there has been a lot of pretrial publicity and media attention, and there will be a section of the case where we'll be discussing that, but for those of you who have been exposed to some of that publicity or have some knowledge about this case through that, please don't discuss any details during your questioning here in front of the other jurors, so that those jurors who do not have that information don't hear it from you for the first time. We'll take those up individually with each of you when we're further into the process here, and allow you an opportunity to explain that more fully. At this time also, I'll instruct the attorneys to please avoid repeating any questions the court's already asked, but the attorneys do have the right to direct any follow-up questions to a juror regarding that juror's response to any previous questions of the court during voir dire. I'll next talk about the nature and purpose of juror challenges. The jury should be aware that during and following this voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, by which I mean each side can ask a juror be excused for some specific reason. In addition, the sides will have a number of what are called peremptory challenges, and those are challenges that each side can exercise without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time, then, the court will commence with its voir dire examination, after which the attorneys for both parties will be given an opportunity to make their own inquiries. The first question I will ask then, as it relates to your questionnaires you completed when you came here last week. I'll ask you as a group, are the answers contained in your questionnaire still true and accurate to the best of your knowledge at this time?
Yes.
Okay, thank you. Let me ask a question now as it relates to the time commitment that will be required if you are serving as a juror in this case. If you are required to serve as a juror here, it will be for a period of time that the attorneys have estimated to be 8 weeks. And the question is whether or not that service for that time would create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case. So if anyone has a response on that time commitment and a concern they believe would create a hardship, would you please raise your red card? Okay, we've got 3. Jurors 1571, 1266, and 1569. All right, thank you for that. I'll review your questionnaires briefly and then take up those questions with you individually, also potentially allowing the attorneys to respond on that issue. So let's start with juror number 1266. If you'd raise your card again, please. All right, thank you. I note in your questionnaire, juror 1266, you didn't check or explain a hardship there. Is there something that you'd like to advise the court of at this time on that issue?
I'm the sole breadwinner in our home, and I'm taking care of my wife. She's ill, and my mother-in-law lives with us, and I take care of both of them. And if I'm out for 2 months, there ain't going to be any money coming into that household, and I'm going to have a lot of bills piled up by the end of that.
All right, let me take a quick look at your, you still have the occupation of a supervisor of a shop?
Yes, sir.
And if you are not there working, you don't get paid, is that accurate?
That's right.
Okay. Did you discuss at all with your employer the possibility that you may be required to serve here?
Yes.
Did they indicate they could make any kind of accommodation for you?
They were thinking about it. They say that for this week here, they're going to give me some time, but if I go on longer than that, I'll probably have to take all my vacation and then whatever else I got.
Okay. And could you explain a little bit more about the other part of the hardship beyond the financial side of who you're taking care of?
My wife.
Okay. All right, I'll allow for some follow-up voir dire on that specific reference for both the state and the defense as to juror 1266 on their request for excusal for hardship. Does the state have any questions?
Your Honor, the state has no objection to excusing juror 1266 for hardship.
All right, would the defense like to ask any questions?
Your Honor, the defense has no objection to excusing juror 1266.
Okay. Based on those responses, as well as this court's review of your responses today in your questionnaire, I'll allow you to be excused, finding that it would constitute an undue hardship for you to have to serve in this case, given the length of the trial. I'll let you know something before you go, and if any other jurors are excused for any reason, please keep this in mind also. So that will complete your service as a juror in this case, and we appreciate your time coming in, filling out the questionnaire, and being here today. If you decide to discuss this case with anyone, be careful to respect the privacy and feelings of your fellow jurors, and please limit your comments to your own perceptions and feelings. If someone persists in discussing this case over your objection or becomes critical of your service for any reason, please report that to the court, and we may follow up on that issue. So I appreciate your time coming in today, and you can be excused. Next juror I'll discuss the hardship issue with is juror 1569. All right. All right, in this questionnaire also I didn't see any explanation as it related to hardship. So juror number 1569, would you indicate to the court why you believe it would be a hardship for you to serve in this case?
I just received word this morning from my Human Resource Department that they would only allow 30 days. And anything beyond that, I would not receive compensation.
Okay, if this trial were to go for roughly twice that length of time for 8 weeks, do you believe it would pose a financial hardship that would be an undue burden for you?
I do.
All right, thank you for that follow-up information you received from your employer. Let me ask the state if the state has any questions and wants any follow-up or dire with this juror.
Your Honor, based on that information, the state has no objection to excusing this juror for cause.
Thank you, Mr. Wood. Mr. Archibald, do you have any voir dire for the juror?
We do not object to juror 1569 being excused.
All right. The court's reviewed that response as well. I do find that based on your response given today that serving for the entire period of this trial would constitute an undue hardship for you. So for that reason, you could be excused. Thank you for your service, and the same admonishment I gave the other juror about who you discussed the case with or reporting to the court any unwanted contact will apply as well. So you can be excused, and thank you for coming. All right, finally, juror number 1571. All right, juror number 1571, I've reviewed your questionnaire. You didn't expressly indicate a reason why it would be a hardship then. Would you describe to the court why you feel it would be a hardship if you had to serve in this case?
I'm just in a difficult situation. I'm unemployed right now. I'm trying to find work. I didn't state it because I'm not quite sure. I'm having a hard time getting interviews and things like that, and so as far as the time frame, I don't have any resources at this particular point in time. So I could, I guess, technically serve, but it will prevent me from finding anything. So that's why I didn't state it. I'm not quite sure because I'm in this difficult spot. I just don't have any resources coming in.
All right. I'd ask the state if there's any follow-up for Dyer for juror 1571.
No, Your Honor. Based on the representations of this juror today and in the questionnaire, the state has no objection to excusing this juror for hardship.
All right. Mr. Archibald for the defense.
Your Honor, we do not object to juror 1571 being excused.
Very well. The court's reviewed the questionnaire as well as the responses provided by this juror. I do find that it would constitute an undue hardship for this particular juror to serve at this time given the length of the trial and his unknown employment situation and efforts to find employment. For those reasons, then, juror 1571, with the thanks of the court, you may also be excused in this case with the same admonishment given to those previous jurors about contacts once you leave. Do you have any questions about that?
No, sir.
Okay, thank you so much for appearing today. Then you can be dismissed, and we will move on to further questioning. All right, it's my understanding those were the responses as it related to any difficulty with the time commitment. Was there any other juror that had any issue to raise on that matter? All right, I'll next just briefly make an overview regarding the knowledge of the case. We'll come back to that topic, as I mentioned, individually for each of you. However, in order to get the list of who we're going to talk to about that, let me just ask here of this jury pool, who here both indicated on their questionnaire and would say today that you have had no prior knowledge of this case through any of the media reporting in the case? All right, so jurors 1238 and 1370. Thank you for that. We'll discuss the issue of that later individually with the rest, also 1758. And 1210. Okay. We'll also review your questionnaires, and if either of the parties have any follow-up questions, those can be brought up as well. Let me next move on to the issue of the subject matter of this case. I explained already the nature of the charges in this case, but reiterating that the charges here involve charges of murder, conspiracy, and theft. Is there anything about the nature of those charges in this case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? All right, no one answered affirmatively to that. I'll ask some further questions here, which you'll probably think should be obvious by what you said in your questionnaire, but I need to ask those to cover legal challenges pursuant to Idaho law. In regards to any relation to or acquaintance with the defendant, are any of you related by blood or marriage to the defendant, or do you know her from any business or social relationship? Okay, no one responded to that question. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys in this case? Are any of you, and I'll note on the record there was no response to that question, are any of you a party in any civil action against the defendant in this case? There was no response to that question. Have any of you ever brought a criminal complaint against the defendant, or have you ever been accused of a crime, of a crime by any of the prosecutors in this case, including Ms. Blake or Mr. Wood? Okay, there was no response to that. I'll next discuss whether there's any representation or relation by the attorneys. The question is whether any of you have an attorney-client relationship with any of the attorneys or with their law firms. So in order to fully answer that question, at this time I'll ask the prosecutors to introduce themselves again and indicate who they work with in their office, and then I'll ask the same of the defense. So starting with Ms. Blake, who's in your office, and then we'll move on to Mr. Wood.
Your Honor, if it's all right, I'll just answer for both of our offices.
Yes.
Rob Wood, Madison County Prosecutor, and in that office we have Mackenzie Cole, Spencer Rammel, Adam Garvin, Troy Evans, and as stated by the court, we've deputized Rachel Smith to help with this case. In the Fremont County Prosecutor's Office, there is Lindsay Blake, Tanya Rawlings, Rocky Wixom, and Blake Hall.
All right, thank you, Mr. Wood. For the defense, Mr. Archibald.
I'm a sole proprietor.
All right, and Mr. Thomas, who do you work with in your office?
There is Jordan Crane, Jason Gustavus, Timothy French, Alex Sosa, Tyler Salveson, Brad Rigby, Paul Butikofer, and Justin Bowles.
Thank you. Now that the counsel have indicated who all they work with, let me ask the question again. Do any of you as jurors have any attorney-client relationship with any of the attorneys here or anyone mentioned that they work with? All right, there was no answer to that question from any juror. Are any of you jurors related by blood or marriage to any of the lawyers in this case, or do any of you know any of the lawyers from some prior professional, business, or social relationship? Okay, no one answered affirmatively to that. Let me next ask a question relating to whether you have prior jury experience. If you've previously sat on a jury that went through a trial, would you please raise your red card? Okay, 1133. Has anyone else previously served on a jury? Okay. Juror number 1133, would you just explain when the case occurred, where it was, and if you recall what the outcome was? Was it a criminal or civil case?
Yeah, it was a civil case, and I think it was approximately about 20 years ago, and it was like a car accident type of case, and it was a non-guilty verdict.
Okay, and do you recall where that was that you served?
It was in El Dorado Hills. California.
Okay. Is there anything about your prior service on that jury that you think would affect your ability to sit as an impartial juror in this case now?
No.
Okay, thank you for your response there. I'll next ask a general opinion to the jurors, but a obviously important question. Have any of you ever formed or expressed an unqualified opinion that the defendant, Mrs. Vallow Daybell, is guilty or not guilty of the offense charged? There was no response to that question. Do any of you have any bias or prejudice either for or against the defendant in this case? Okay, no one answered affirmatively there. When you completed your questionnaires, there was a list of potential witnesses in this case. Those can be reviewed by counsel within the questionnaire, but I'll just ask you as a group, are the answers you provided in that questionnaire still accurate to the best of your knowledge as it relates to any witnesses you may know? Okay, thank you. Is there anyone here in this jury pool who would be unwilling to follow my instructions to you, the jury, as to the law that you must apply in determining this case? Okay, no one answered that question. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict in this case? All right, no one answered yes to that. Are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? Okay, no one had an affirmative response to that question. And then finally, do any of you have any other reason why you believe you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, no one responded to that question either. At this time then, the court will pass its voir dire to counsel for their voir dire in the case, beginning with the state.
Thank you, ladies and gentlemen. Again, my name is Rob Wood. I represent the people of Idaho in Madison County. Just really briefly, if any of you thought it was strange that there's two county prosecutors here, as you may or may not have noted when the court read the indictment the other day and then summarized it again today, there are allegations that crimes were committed both in Fremont and Madison County. So that's why there's two county prosecutors here. Before I get into any questions, just wanted to reiterate, if you do have anything you feel like you need to tell us, but you think it might be embarrassing or it's just really personal, please just let us know and we can do it individually. We want everyone to feel like they can answer everything honestly and totally. And so speaking of that, I want to talk to you about the phrase brutal honesty. Juror 1276. If I ask you, you're all right. If I ask you, what does brutal honesty mean? What is your response?
Giving the truth regardless of what the result will be.
Okay. What about juror 1210? What does that mean to you, brutal honesty?
Giving the truth without regard to someone else's feelings.
Okay. Thank you. And the reason I'm asking that, there's a defendant here today who's been charged with very serious crimes, and she is absolutely entitled to a fair and impartial jury and a fair and impartial trial. And we have to rely on what you tell us to make sure that that happens. Not only is she entitled to a fair and impartial trial, the people of the state of Idaho are also entitled to a fair and impartial trial. And so it's too important to the defendant, it's too important to the people of Idaho to not have honest answers. And I would add, to me, part of that is complete answers. So please make sure that you give us a complete answer. Just a real brief analogy. Who here has flown on a plane? I think everyone raised their hand. We all know how it goes. You get on the plane, you stow your luggage, and the pilot tells you, we're going to land at such and such place at such and such time. How many of you would feel comfortable if a pilot said, I might be able to land this plane? Nobody would feel comfortable, right? Because he's not getting you where he's supposed to get you. He's not doing what he needs to do. So, ladies and gentlemen, today you're the pilot. And when you're answering the questions, we need you to land the plane. And what I mean by that is that you give us those true and unvarnished answers. The judge spoke just very briefly about will you follow the law as it's given to you? Who here can think of a law or a rule at work or some regulation they don't particularly care for? By raise of hands. Almost everybody. Almost everyone can think of a law or rule they don't care for. And that's fine, because we all have different opinions. And we all think different things are fair. But what one person thinks is fair is different than what another person thinks is fair. And so for the defendant and for the people of Idaho to have a fair trial, there has to be an objective rule of law. And we all have to agree to abide by that law. And so when the judge gives you the instructions, it's possible you may not like the law. Can everybody here commit that whether you agree with the law or not, that you will follow the law as given to you by the judge or by the court in this trial? Can you raise your hands and commit to that? Thank you. And that might come up a little more later, but the judge spoke about pretrial publicity. Juror 1323. Do you believe everything you see on the internet?
Do I what?
Believe everything you see or read on the internet?
Absolutely not.
Absolutely not. Why not?
Because not everything out there is true. Some people put out fake stuff, true stuff. So, no, I don't always believe what I see.
Okay.
I do my own research into it if I'm wondering if, whatever I see, and then form my own opinion.
Okay. Is there anybody here who disagrees with Juror 1323? Juror 1273.
Yes.
Do you believe everything you see on TV?
No.
You sound pretty emphatic.
Yes.
Why is that?
Because television is meant for entertainment. It's meant to sensationalize. It's meant to keep you engrossed and coming back, and things like that require something that captivates the audience. Okay. And so it's not always going to be true. It's going to be something that's going to hook you and make you want to come back.
Okay. Does anybody disagree with Juror 1273? No? I'm not seeing anybody raise their hand. Okay. And so, as the judges said, and as we will talk about later, there has been a fair amount of pretrial publicity about this case. Can everyone here commit that you will put aside everything you've learned from the media or outside sources and only make a decision in this case based on information received in this court? I raise a hand. Can everybody commit to doing that? going to briefly speak, and the judge mentioned this, the nature of the case. The defendant in this case is charged with the murder of 3 individuals and conspiracy to commit murder. 2 of those individuals are minor children. In your questionnaire, you were asked if it would bother you to see autopsy photos. And so some of the evidence in this case will be, I'm going to use the words emotionally charged, and difficult to look at. Juror 1106. Just me telling you that, how do you feel about that?
I have seen a dead body before, so that's how I feel. You know, I knew how I reacted to that, which was fine, and I had to deal with what I needed to take care of with it. I went to somebody's house. I thought they were having a problem, and somebody was actually had died, and so I had to. You want me to tell the whole story?
Well, just briefly.
Briefly. So it was refugees that I work with. They didn't speak English. I didn't speak their language. The coroner was there, and they wanted somebody to get those people off the body because they needed to take it. That was me. So that was part of, one experience that I've had was walking in and not expecting it and seeing a body.
So you've had some experience then with something similar to that?
Yes.
So we need the jurors on this case, both the defendant and the people of Idaho need the jurors on this case to act with common sense and reason. So juror 1106, if you see images or evidence that is emotionally charged, do you have any concerns that your response to that will overrun your reason and common sense in making a decision?
I have no reason to think that, no.
Okay. Is there anyone here who thinks that seeing that type of evidence, emotionally charged evidence, such as an autopsy photo, will overrun their reason and common sense in making a decision? This is where that brutal honesty comes in. I'm not seeing anybody raise their hand. Okay. Is there anyone here who will, let me ask it this way, can everybody here commit that seeing that information, that you will still consider all the other evidence in the case and not make a decision just based on that emotionally charged evidence? Okay, everyone who feels like they can do that, can you raise your hand? Okay, and you can do that. Okay, thank you. I'm going to turn the time over to my colleague, Ms. Smith, and she's going to ask a few more questions. Thank you.
Good afternoon. I'm going to follow up briefly on some things, and we're going to talk about some of your questionnaires, okay? Let's just talk. Let me turn quickly to Juror 1106. In looking at your questionnaire, there were some questions where I think you marked on there that you didn't understand some of the issues about beyond a reasonable doubt. Do I have that right?
That's correct.
Okay. Now, did you hear the court's instruction on that issue?
Yes.
Okay. Did that help clear it up?
No. To be honest with you, no.
Okay. Fair enough. And it's hard, especially, I'm a visual learner, so if I don't see it. So let's talk about it a little bit. I also see, let me make sure I have my right juror, that you work in a pharmacy, correct? You're a pharmacy operations supervisor?
I'm not a supervisor. I work in health insurance and pharmacy in our pharmacy department.
Okay. Do you actually work where narcotics are stored, or are you more in an office?
No, I work from home. Not any longer. I have in the past, but no.
Okay.
I do not work around medicine.
Okay. let's do this. Let's say that you were with a visiting relatives and there were some children present. Okay? And the children were told to stay away from the cookie jar in the kitchen. Okay? And every adult made it really clear, stay away from that cookie jar. And then you come into the kitchen and you see one of the very delightfully cute little kids standing there, and the cookie jar's open. There's crumbs on their hands. There's chocolate on their face, right? And it's, you look at them and you go, why did you eat that cookie? Right? Based on what you'd seen, would that firmly convince you that they had eaten that cookie?
No.
Okay. Why not?
Well, they just have crumbs. Maybe there were no cookies.
But there's chocolate on their face.
Maybe it was remnants in the bottom of the cookie jar.
Okay. Okay. And so if you saw those pieces sitting on their face and they wouldn't answer you when you said, hey, did you eat that cookie? They just wouldn't talk. Would that help you be firmly convinced?
No, unless I seen them eat the cookie, would I know?
Okay. So I think that it probably, that tells us a lot, because unless you see it or see an item, or unless I saw him do it, you couldn't make the decision that you couldn't be firmly convinced.
Correct.
Okay. Now let's extrapolate that to this situation. Are you going to be able to have people show you bits and pieces of things and reach a conclusion that leaves you firmly convinced that a crime occurred? Or do you have to see it?
I would say no, I do not have to see it, because I would look at a bunch of different evidence and have to make that decision from there. And if I wasn't 100%, then I couldn't make that decision.
All right. If I wasn't 100%, you couldn't make that decision?
Yeah, if I wasn't 100% sure that child ate that cookie, I can't say you ate that cookie.
Okay. Even if you received an instruction from the court saying, hey, if you're firmly convinced, even if it's not 100%, but you firmly convinced based on logic and reason, and the court says you don't have to prove it to 100%, you don't have to remove all doubt.
That's probably where my answer was. I was a little bit confused on that questionnaire with that one.
Yeah.
For exactly what you're saying.
Right. And that the reason it's on, everything on that questionnaire is there for a reason, because there are people who are like, Your Honor, Ms. Smith, I understand what the court's telling me, but I need to be 100%. I need to be more than firmly convinced. I want to see it. And do you think you're in that position where you need to see it?
If I didn't see it happen, then I'd have to be convinced by other means. And that would be with the jurors, or, in deliberation, that sort of thing. I would have to know. I'll go back to the cookie thing. I'd have to, if it was that thing where I'd have to, hey, did anybody see this cookie? Or the kid eat the cookie? That sort of thing.
Okay. And so, without getting too far into the court's instruction, because we have to follow the instruction that's given us by the court, let me do it this way. A person who witnessed the child or anyone doing something, that person's a witness, right? Can a witness ever be a juror on a case that they're a witness on? Have you ever heard of that? No. I see lots of shakes of head. No, because so the person who's 100% because they saw it couldn't be a juror, could they?
I don't know law. I don't know.
Okay. Let me tell you, under the law, they can't. If you're a witness, you can't be on the jury. You can't see it, be a witness, and then also sit in judgment. Does that make sense?
That makes sense.
Right?
When you say it that way, yes.
Right. And so jurors are having to take evidence that is given to them and supplied in the courtroom, ruled admissible by the court, and consider that evidence, and then make a decision that leaves them firmly convinced. And so while a witness can be 100% certain of what happened, jurors have to be firmly convinced. Does that make sense?
Yes.
Okay.
Yes.
And only you know what's inside your head. Do you see the difference between those two things?
Yes, I do.
Okay. And only you will ever know, look, if I don't really see it, if I'm not 100%, I just don't think I could sit in judgment and consider convicting someone. Or can you extrapolate, and if you believe each part of the items given to you beyond a reasonable doubt, if you're firmly convinced, you could convict. So we need to know, do you need to be that sort of 100% all doubt removed? Or can you be in the category where you're firmly convinced?
Your Honor, firmly convinced is not the burden of proof in this case.
I do agree. I think we've discussed that term too many times, Ms. Smith, and it may confuse the jurors about the correct standard of proof in this case, which the court's instructed already with its instruction of what constitutes beyond a reasonable doubt. So I just request that you modify your line of questioning to comport with that.
Sure. Jurors have to believe and use their reason and common sense to believe that a crime has occurred. All right? Understanding that, do you still feel you're confused on beyond a reasonable doubt?
No, you've helped a lot.
Okay.
I understand.
Okay. So understanding that, does that sort of change some of your answers on your questionnaire?
No.
Okay. All right. Fair enough. Your Honor, I'd move for cause on juror number 1106.
On what basis?
On the basis that she can't follow the court's instructions.
Was that on responses made today on the record or responses within the questionnaire?
Both, Your Honor.
All right. Would you direct me where in the questionnaire you're referring to?
Let me pull up. It's loading, Your Honor. What page is it? Mine's just so slow to load.
Page 7.
Page 7, Your Honor. Look and see. Let me see. Your Honor, it's page 7, lines 8 through 11.
All right. Would the defense like any response to the challenge for cause on this particular juror? Yes.
Judge, may I unmute the simulcast?
Thank you.
Good to go, Judge. Thank you.
All right, thanks. The court has before it a challenge on juror number 1106. I just had a brief sidebar with counsel. While the court would not find cause exists based on the responses as they relate to the standard of what is beyond a reasonable doubt as defined in the instruction the court previously read, upon further review with counsel, the court found other grounds based on potential bias as it related to some questionnaire responses involving some media exposure, and the court understands at this time that both sides feel it would be best to excuse this juror. Does the state agree that for those grounds, juror 1106 can be excused?
Yes, Your Honor.
Does the defense agree as well, Mr. Archibald?
Yes, Your Honor.
Okay. Well, based on that and having reviewed further the questionnaire, again, not based on the responses to that line of questioning in particular, but for other reasons as indicated in the questionnaire, juror 1106, I'll allow you to be excused based on that challenge and sustain that with the stipulation of counsel. So you will be excused. As I indicated from that prior instruction, if you wish to discuss the case, please respect your fellow jurors' privacy and feelings if you do that, and if you if somebody is insisting on talking to you and you don't want to discuss the case with them, please report that to the court. With that, the court extends you its sincere thanks for the time you've put in today and last week in this case, and your jury service is through for this case, and you're excused. Thank you.
Thank you.
All right, Ms. Smith, you can continue your voir dire of the panel.
Thank you. And one of the things that is so important to both sides, Ms. Vallow Daybell and the people of the state of Idaho deserve a fair trial. And because of that, we have to ask sensitive topics. And sometimes that just means this case is not for the person who's in that chair. Does everyone understand that? We're not intending to pry or be difficult, but both sides really have to do their due diligence and follow up. So if we do that, please don't be offended. Please know we're just doing our best to make sure that both sides get a fair trial. Is that okay with everybody? Okay. All right. Juror 1133. I see that there was some questions about reasonable doubt. I'm not going to rehash that. I think everybody had followed our conversation. But I want to ask you a couple other questions. Okay?
Okay.
All right. You understand that in a criminal case, when the people of the state of Idaho bring charges, the people, the prosecutors, have to prove that crime beyond a reasonable doubt. You understand that?
Yes.
That means only the prosecution has to do anything.
Yes.
Okay. Do you understand that every defendant brought before a court on charges from the state has a presumption of innocence?
Yes.
Okay. And with that presumption of innocence comes the state has the job to prove each part of the crime beyond a reasonable doubt.
Yes.
All right. Now, in your questionnaire, I want to make sure that that there's nothing about sort of the conversation we've had today that would be confusing to you in terms of whose job it is to prove the charges. Whose job is it to prove the charges?
Prosecution.
Okay. And what level, how do they have to prove it? To what standard?
Beyond a reasonable doubt.
Okay. And if the prosecutors fail to do that, what happens?
You're not guilty.
Okay. And so the judge is going to give you those instructions. You actually get to take them back with you when you go in for deliberations, and you get to read them. And so jurors can't add to that and they can't take away from that.
Correct.
Okay. And so that means that a juror has to agree to follow the law and hold the state to beyond a reasonable doubt. Nothing more and nothing less.
Correct.
Okay. Do you have any concerns on that?
Not at all.
All right. You did serve on prior jury service, I see.
I did.
Okay. And forgive me, I didn't write it down. Was it civil or criminal?
A civil case, a traffic
okay.
kind of accident type case.
Okay. So, and the court has asked you that. Were you the foreperson?
Excuse me?
Were you the person in charge who had to sign the piece of papers?
No.
Okay. All right. All right. Thank you.
You're welcome.
Okay. Juror 1210. Okay. The notes indicate, and again, if this is something we need to talk privately, we can, but your wife is an assistant prosecutor in Ada County? Or does she work at the Ada County prosecutor?
She's a receptionist for the public defender's office.
Oh, okay. Oh, okay. I must have misread.
I think I put one down wrong.
Okay.
It asked multiple times on there, and I think I wrote one of them down wrong.
Well, and that's why we do this. A lot of people will go, wait, why are you asking me about my questionnaire? For that exact reason, right? Is there anything about her work in that office or any stories she might have told you about the courthouse that you could be weighing on your mind or you'd be thinking about while you're evaluating the evidence on this case?
None.
Okay. And so you understand that the state bears the burden of proof?
Yes.
Okay. Now, that means when we make accusations of the charge of conspiracy, okay, that individuals are charged for conduct and working with others to achieve a certain end, right?
Yes.
Okay. And in that situation, the state has to prove all those parts that they charge on the conspiracy. Does that make sense?
Yes.
Okay. And that the person had to be a part of that conspiracy and contribute towards it. Does that make sense?
Understood.
Okay. And so when that happens, a person can be responsible for the entire outcome, even if they only did certain parts.
Yes.
Okay. So, for example, the driver in a bank robbery, the driver of the getaway car, is guilty of the bank robbery even though they just drove the car. Does that make sense?
It does, yes.
Is there anything about that situation that would cause you concern?
No.
Okay. Does it make sense?
Yes.
Is there any of the other jurors who are like, look, I can't treat the driver of the car or the planner as the same as the person who robs the bank? Does anybody have concerns with that? Okay. I see shakes of heads. I know it's been a long day. I appreciate you hanging in there with us. All right. Okay. Juror 1273. Okay. Did I read the questionnaire correctly that you have triplets?
Yes.
Busy. Okay.
Yes.
All right. And how old are they? Forgive me, I didn't write that down.
They're 13.
Okay.
Boys.
You're busy. So having 13-year-olds, boys, one of the victims in this case was younger than that, but a boy, and then there's the victim, the girl is slightly older than that. Okay. Having children in that age range, knowing that the victims, the people who died in this case, are in that age range, are you going to be able to make sure that you provide Ms. Vallow Daybell the presumption of innocence? I'm sorry?
Yes.
Okay. You understand that it's natural human reaction to dislike or feel sad about the death of children, correct?
Yes.
And as a mom, it's not unusual to feel that emotional overcharge when you see those issues, right?
Yes.
Okay. But can you assure us that your personal situation won't make you automatically convict someone?
Yes.
Okay. Is there anything about your home life or the fact that you have 13-year-olds, 3 boys, that's going to cause you to make it easier on the state? Say, you don't have to show me as much evidence.
No.
Okay. And I don't want to, we can circle back if we need to. Mr. Wood asked a bunch of questions about the pictures. What about your juror 1276? Did I read that correctly, that you have 3 kids but a 15-year-old?
Yes.
Okay. You heard my questions that I asked of juror 1273?
Yes.
Okay. Do you have any concerns with those questions? Would your answers be different than hers?
No.
Okay. All right. You can judge the facts and the evidence based on your reason and your common sense.
Yes.
And so, juror 1276, the judge is going to give you those instructions. He's going to define, and you're going to get to take back the instructions, definitions, back to the jury room. Okay? And when you get those definitions back there, it's going to tell you what has to be proven beyond a reasonable doubt. But it's not going to tell you how the state has to do it. It's not going to give you a formula that you have to have this type of evidence or this many witnesses. Do you understand that?
Yes.
Okay. And so I got to ask, is there anything about this situation where you're thinking in the back of your head, I would kind of like to see this type of evidence?
No.
Okay. You understand that the state bears that burden, but the judge isn't going to say what we have to do, only that we have to accomplish it.
Yes.
That can mean, and I'm going to use the circumstantial evidence sort of example of the cookie crumbs example. If you walked in and you'd told your 15-year-old, don't touch the cookies, they're for dinner tonight or for afterwards, and the 15-year-old standing there, chocolate on his hands, chocolate on his mouth, crumbs down his shirt, nobody else is in the room, and the cookies are missing, right? Are you going to be firmly convinced that that 15-year-old ate the cookies, and are you going to ask him, why'd you eat my cookies?
I don't think I'll be firmly convinced.
Firmly convinced?
Yeah, I'm sorry.
Would your reason and common sense lead you to conclude?
Oh, yes.
Okay. Yes. Let's do it that way. Okay. So your reason and your common sense would lead, and would you hold him accountable for it and have a consequence for disobeying you and eating the cookies when he shouldn't?
Yes.
Okay. And so that, even though you didn't see him eat the cookies, but the different pieces of evidence led you to conclude he'd eaten the cookies, right?
Yes.
And you're going to hold him responsible and give him a consequence.
Yes.
All right. And so that's what they call circumstantial evidence. And so you would be holding him accountable based on circumstantial evidence. Does that make sense?
Yes.
All right. Now let's take that and apply that to this situation. All right. Let's say the state, you get the instructions from the court. You go back to the jury room and the court's given you the definitions. And the state is giving you circumstantial evidence that proves to you beyond a reasonable doubt each one of the parts of the definition the court gave to you. Can you consider convicting somebody using your reason and common sense to convict somebody when the state has given you only circumstantial evidence?
Yes.
Okay. Hard, but you could do it. Mm-hmm. Especially if you received an instruction from the court saying you have to use your reason and common sense to walk away. I appreciate you thinking about it, and that's exactly what we need. Any hesitation on that?
No.
Okay. Now, everybody has probably heard my conversation with juror 1276. Is there anybody here who's like, Ms. Smith, I heard that? And I understand what you're saying, but I don't think I could consider convicting somebody, even if I was firmly convinced of each part, based on circumstantial evidence alone. Can everybody assure us you can consider that issue? And if you're firmly convinced, consider convicting someone based on circumstantial evidence? Okay, thank you. Another thing, let me see. I think I have a couple people. Juror 1370. Thank you, ma'am. Did I see that you have a nursing degree?
Yes, I do.
Okay. And in part of your nursing degree, did you take any work in like the pathology lab, or did they have you work in that? Or did you not go down that path?
No, that's not part of the nursing degree. It's more the interpretation of the results that come from that department.
Yeah. Have you ever had to be a part of that?
No.
All right. There's going to be evidence from some forensic pathologists. Okay. The MD, the MEs, the coroners, that sort of person. Have you ever had any contact with any of those people?
I mean, I've had like coroner cases where like we have to let the coroner's office know when they come and technically investigate the death, but outside of that, no.
Okay. And so you used a phrase, investigate the death. So you're aware of the concept of what coroners have to do, right?
Correct.
All right. And so coroners will investigate a death and medical examiners will investigate the death based on what your experience is, right?
Correct.
And they kind of they try to decide how the person died and what type of death it is, right?
Correct.
All right. How they died, like what thing caused their heart to stop bleeding, pumping, and their brain to stop functioning, right?
Correct.
All right. And then the medical examiner and the coroner then talks about what type of death it is. Was it the death at somebody else's hands, right?
Yes.
Okay. So, there are situations, can you consider situations where the medical examiner or the coroner might tell a jury to consider convicting somebody of murder, even if they can't exactly say the cause of death, what caused the person to die? They can tell it was a homicide in their opinions, but they can't tell what actually caused the heart to stop beating. Does that make sense? That situation could happen?
Yeah, it does.
Okay. And given sort of your nursing and some exposure to the concepts, do you think you could consider convicting somebody of murder if the state can't show you exactly how they died?
Yeah, it's really hard to actually prove everything every time because things change after people pass away.
Exactly. And so if the state could prove that someone died at the hands of another and all of the elements of the instruction, but couldn't exactly tell you exactly what caused their heart to stop beating, could you consider convicting somebody of homicide?
Yeah.
Okay. Is there anybody here who heard that? Thank you, ma'am. I appreciate it. Is there anybody here who heard that exchange with Juror 1370 and is like, Ms. Smith, that's pushing it. My personal beliefs wouldn't let me do that. Can everybody assure us they could consider that situation? Hold the state to its burden of proof? All right. Thank you.
This is continuous coverage.
Continuous coverage.
In the trial of Lori Vallow Daybell from the Hidden Killers podcast.
Hidden Killers podcast.
Segment number 4 is coming up for you shortly. Press subscribe so you don't miss it as we continue to bring you raw courtroom audio from jury selection. Day 1 is what we have to deliver to you so far. Keep it here.